The hour of 3 o'clock having arrived, we will call the Human Resources, Finance, and Property Committee to order. First item is the Pledge of Allegiance. Please rise. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. No one has registered for public comment or contacted the clerk or myself. Therefore, we will move on to the March 21st minutes. What are your wishes? Got a motion? Motion is moved by Leahy. Is there a second? Second by Lemmer to approve the minutes. Any discussion? If not, all those in favor will signify by saying aye.
Aye.
Opposed, no. That motion carries. I had a request to take item B9 first, and if there's no objection, we'll deal with the resolution consider in rem foreclosure for tax delinquent properties up first. And Mike, you have, is there an objection? If not, Mike, you've done some background research, and Connie and Steve are here, so I'll turn it over to you.
Thank you, Mr. Chair. Just as a little background for the committee, I've had several discussions now with Connie and Steve at the Treasurer's Office about our tax deed process, and some of those discussions have been about what tools or tweaks do we see that we could add to make the process smoother or more streamlined. One piece that we've discussed is potentially utilizing what's called an in rem foreclosure process for tax delinquent properties, which is a different way of proceeding on tax delinquent properties than the method that we currently use. Kim, can you switch to the WebEx?
Oh, yes.
I have a little set of slides for you all. Okay, perfect. So I wanted to give a little bit of background on what this process is that we're talking about, and then what we're currently doing, what we could look to do, and then any feedback or questions for either myself or the Treasurer's Office would be great. So when we talk about these tax delinquent properties, these are properties within Marathon County that the owner has failed to timely pay their property taxes on. Annually, if there is a property that hasn't paid its prior year's property taxes, the Treasurer's Office issues what's called a tax certificate regarding those properties on September 1st. Once that type of certificate is issued and the landowner gets notice of that, there begins to run a clock, a 2-year clock, which is the redemption period. That's the period that the landowner can come back and pay the back taxes in order to prevent any further action being taken by the county. So once we acquire once we have a tax certificate, so that's a certificate saying you have outstanding taxes, you owe this amount, the clock has started running, our Treasurer's Office gives notice to those property owners of the existence of the tax certificate. After that 2-year period expires, the county is entitled to pursue acquisition of that property through one of the processes that's outlined in state statute. There's a few methods that can be used. The one that we currently use is called the tax deed process, where the county actually acquires the property by tax deed. There's also some other items that I'll talk a little bit about, and there's a fourth way called the in rem foreclosure proceeding, and that's the one that we're going to specifically talk about today. So the two that we don't use at all because they would take way too long and or not be very helpful, the county can also pursue a civil judgment against someone whose property has a tax certificate. So we could go into court and say we want a monetary judgment in the amount of those unpaid taxes. The difficulty with that, of course, is collecting that amount. We have a judgment which is not going to help us collect the money, especially if it's otherwise an uncollectible owner. Counties can also pursue individual properties through a regular foreclosure action. So if you think of a property that has a mortgage on it, that type of foreclosure action can be used. If you use the regular mortgage foreclosure route, you can only do one property at a time, and it's pretty legally cumbersome, which is why counties usually don't go that route. The current process that we use is the tax deed process. So in that process, after that 2-year period expires, where we've given notice that, hey, you have a tax certificate on this property, you have outstanding taxes, 2 years have passed, we then have to give notice to the landowner and to any parties that have a secured interest, so mortgage holders, lien holders, that type of party. We have to give them notice that, hey, we intend to pursue taking your property by tax deed. If we can't find the owner, we also have to publish notice of our application in the newspaper, insert it 3 times. Once that 3-month period expires after we've given that notice, we can transfer the property into a deed under the county's name. Those transfers happen on a property-by-property basis, so it's not limited, or it doesn't allow us to pursue multiple properties at one time. And this is the current process that we've utilized historically in Marathon County. In statute, there's actually a 4th way to go about things. It's called the in rem foreclosure process. In rem, in this case, meaning against the property. So it's actually an action against a set of properties, not against a landowner themselves, although the landowners obviously still get notice of this process. Counties can't pursue this in rem type of proceeding unless the county board has, by ordinance, elected to allow it. Once a board has elected to do that, what we do, instead of after that 2-year redemption period giving notice that, hey, we're going to take your property by tax deed, instead, for every property that has a tax certificate with a 2-year redemption period that has passed, we file a whole list of all those properties with the courts. Notice goes to all the property owners and all the lien holders, and then instead of executing on them property by property, this process allows the county to actually pursue foreclosure on all of the listed properties at one time. The cumbersome foreclosure of mortgages rules don't apply, so it has particular legal procedures that are separate from the normal foreclosure process. Once we start that in rem process, there is still an 8-week redemption period for the owner to come back and try to redeem that property. As I said, this in rem process has to be adopted by ordinance. If it's adopted by a county board, it can't be repealed for another year. Another positive is that even if a county adopts proceeding with this in rem process, all the other enforcement options for a county are still available. So on a particular property, we can decide this one we want to do tax deed, but this set we want to do in rem. Once we decide to go either route, though, we can't switch in the middle and say, oh, well, we're halfway through the in rem process, now we want to get a tax deed. We can't do that. But if the board were to elect allowing us to go through this process, we would have the ability to go either way with particular properties. And then once we go through the court process in the in rem foreclosure process, the ultimate judgment gives the county the same result as a tax deed. So the former owner is barred, the title is quieted, the county gets fee simple estate of that property. So there are a couple differences between the two processes that I wanted to highlight for the committee. Obviously, the biggest difference is the in rem process involves court filings, proceeding through court and getting a court order. Tax deed, we're pursuing the transfer of a deed and transfer of ownership without a court order. From a legal perspective, I do see some benefit to having court involvement on the front end to receive that court order approving the transfer. I think that in some ways limits the county's liability in the event notice in the tax deed process is challenged later on. It's harder to challenge that when we've gone through the court process, given notice, the judge has found notice is sufficient, all that. The interim process, the biggest advantage is that it allows execution on an entire list of properties. So if you have a list of 50 outstanding properties, you can file that list in court, handle all of them at the same time in the same court proceeding. Both processes, when you're looking at getting to the stage where you have a tax certificate, the same work goes into that. So the same upfront staff work is included. The notice of tax certificate is required. The 2-year period has to expire before you can even proceed either way. And if we were to elect to proceed in REM, the Treasurer's Office would be involved in putting together that list of the outstanding properties with tax certificates that could develop an advantage of having that list developed. The notice requirements between the two processes are similar. The courts are going to require the same type of certified mailing under the in rem statute that we're supposed to do and required to do in the tax deed area. And if we can't find an owner, we're still going to publish in the newspaper. So the notice is very similar. In the event that we have properties where we don't know who the owner is, it's highly recommended that a court appoint a guardian ad litem to represent the interests of anyone who might be the owner of that unowned property. There is an additional cost to that. The cost of the guardian ad litem being appointed, that has to be paid by the county. That would then protect the county from further judgments on that property being challenged. So it's a minor upfront cost, which gives us, I think, more certainty in the title once it passes. The entire sale process, though, is unchanged. So whether you elect to go in rem or not, the sale process is governed by a different set of state statutes and our general code of ordinances. So this wouldn't affect the sale process. It would only affect how we are able to take these properties and have title passed to the county so that we can get to the sale point. So if the county was interested in electing to proceed in rem, there's actually a specific resolution or actually ordinance that state law requires to be passed. I have drafted that in a format that could go to the board if you chose to move it there. What it does is indicate that the county board ordains to elect and adopt the provisions of 75-521, that's the in rem statute, for the purpose of enforcing tax liens. And that's all it really says, but that would allow us to do it moving forward with the understanding we'd have all those other tools as well if the case called for it. So that's an overview. I don't know if Connie and Steve, if you have anything in particular. Connie approached me with this as an idea. I know a lot of counties have transitioned to the in rem process because of the ability to list multiple properties at once, and especially as more and more delinquent properties come onto the rolls, it's easier to deal with them in bunches than one by one. So that was the initial idea, and it would have some, from a legal perspective, I think it would have some advantages as far as your eventual title being harder to challenge if someone attempted to do that.
All right, are there, Supervisor Leahy?
Thank you, Mr. Chair. I guess then, are there any apparent immediate disadvantages to adopting this? Or it kind of just sounds like it's giving us another option in a way. We could still do the standard tax deed procedure when we need to.
I think your read there is correct in that the statute very specifically says even if you adopt this, you still have all of the other tools available. So this adds another tool. If you go through the first in rem process and find some issues, we still have the ability to go through and handle another set through tax deed or go for a civil judgment. So I think from that perspective, there is an advantage in giving the county an additional tool to use in the case where it's warranted.
Supervisor Jean.
Thank you, Mr. Chairman. I guess the question I would have for the administration or the clerks and treasurer's office is that, is there in a large amount of individuals that are foreclosing in their homes or not paying their taxes, I guess, that we would need this as a tool. Let's start with that first.
Hello? Okay. Yes, we do. So we just got through last year. We got about 96 people to pay off the list. But now we added another year, 2019, so it increased again. So there are properties that we can deal with going to INREM, which would get rid of those as people just don't want them. But then we have the properties that are a little bit more on a legal standpoint that we need corp counsel for, which are the ones we're attacking right now. So every property is different. And as soon as people are being notified that we're going after them, like just this week I've got about $89,000 potentially coming this week from 3 different properties right now because they're worried and they're finally figuring it out. And we have mortgage companies that are going after them and saying, hey, you didn't pay your taxes. So people are getting warned about it. They're getting letters from their banks. I have been active with management on banks saying that, okay, you guys have mortgages, you have customers, you need to be watching that they're paying their taxes. This is flagging them and they're realizing that, oh, they haven't paid their taxes for how many years? So they're going after them now. Insurance companies are going after them saying you're a high risk right now, you need to pay your taxes or I'm not insuring you. So there are other avenues that are affecting this, but I think the INREM will help us get through a lot of these properties right now.
So let me just remind the committee that, so what Michael has laid out is basically a process where after the 3rd year of tax delinquency, so you've got the first year, if they haven't paid by the July 31st date, in September we issue the certificate. And they've got 2 years after that, so you've got 3 years of tax delinquency. We have cases now where we have properties that are sitting out there where you've not taken title to them that are into the teens and 20s. Our problem is we can't recover those after the 10th year. So we are buying everybody else's book of business. So the taxes come due, they're not paid, we pay the school district, we pay the municipality, we pay the other local taxing entities, and we carry the debt for them. And so the longer we wait, the less likely we are to recover. I do have some questions for Michael, and we had this discussion. The statutes create some ambiguity relative to special assessments. This wouldn't affect special assessments that are there where in the past we have sometimes held the municipalities harmless on those?
My understanding is that those would not be affected by this change in process.
And then has this been changed at all by the new law where if we sell it for more than we had in taxes that we have to reimburse the homeowner?
No, that portion of the change in law doesn't affect the in-rem process, but it still would apply once we've taken title to the property. So no matter what process we go through to take title to a property, once that occurs, we still have that new change in law kick in where we have to send the surplus back to the homeowner.
Then we have the tax deed exemption under the local governmental unit exemption from environmental liability. That does not change.
That is also correct.
And then you indicated that we can take all of them this way, but is it an all or some? I know in the past we've flagged properties not for foreclosure because of environmental concerns. That remains the case?
Correct. We do not have to take all properties. We can elect which properties we want to proceed in rem on and which we want to proceed in a different way or not at all on. The properties that we list to proceed in rem, we then can't change our minds and go, we want to do a different thing after we've already pursued in rem, but we have the ability to choose which tool we want to use.
And then my final question is that in light of what you provided relative to Fond du Lac and their process, they had clearly delineated roles and responsibilities, and ultimately our success in any effort is based upon the appropriate level of staffing. And this may be more a question for Connie, but if we make the change, I think one of the concerns that several members of the committee have is that we've got this backlog that we haven't dealt with. can we deal with that with some more certainty so that we can eliminate carrying the debt or the obligations for other communities? And do we have a workflow process in place that would ensure success? And if we don't, what would we need?
Sure, I can speak to it a little bit, and then I'll let Connie speak to it more. I think from the workflow process piece, we have a number of other counties who have been doing this for a significant period of time. I think Eau Claire County might have been doing this since 1925 or something like that, so they have an established process. Fond du Lac County, as we included in the packet, has a nice checklist that they assign roles to their staff. It would be very important for us to work out the same type of procedure, one that's unique to Marathon County, obviously, but having roles and responsibilities assigned as it would be in any process. So I think that would need to be part of moving forward. If we've elected to add this tool to our tool belt, so to speak, how do we then make sure it's actually working?
So the NREM with Fond du Lac, she's been doing it for almost 30 years. So it works. And she is, with all of the other county treasurers, we're all struggling with this. And then actually it does go with the Act 216. So because we do have to pay that money back. So right now, in the last year, we've had struggles in our office. It's just me and Steve. So we're the ones that still have to do the letters, and it takes time. It takes a lot of our time to get these letters, and we work with Corp Counsel to get the legal verbiage correct in these letters. Because if we don't, they can come back at us and sue us for any little thing, anything that we possibly miss. So we're working very close with Corp Counsel. We have other letters from different other counties that use the same process. We all are working together. We're not the only county right now that is struggling with these properties. They've increased since the light of COVID. We had the Help for Homeowners. The Help for Homeowners isn't exactly helping a lot of people. You have to file, and they're not exactly paying all of it. They still have money, but they're not accepting their applications. So like for Marathon County, we didn't get a lot of people paid. They're still using the money. We're still getting the checks, but it's just not enough. But these people have had a problem way before this whole COVID problem. So now that we're going after them, they're trying to struggle to find ways of paying for this. We've had a lot of people contacting us, trying to find ways to pay for their property. They don't want to lose their home. There's some that have struggles with their families. They're arguing with the siblings. It's in probate. There's so many different scenarios with these properties that me and Steve are very aware of, and we do have a process on how we're going to handle this. I wanted to talk with Mike and get this started so that me and Steve can focus on getting through these properties as soon as possible. And if we can take a lump sum of them, take them to court, that would help us incredibly. Because some of them we can just send right to court, really easy. And then if they want to come and argue, they can come right to the court and argue. They'll know when it is. So, and I just talked with Mike today. We will be working on verbiage too with letters. So if it does go to the court, they will be probably notified with letters. Do you want to say something?
Kurt?
Thank you, Mr. Chairman. I got several questions. I guess, first off, how many properties do we have that are really right now at the point of actual taking, or they're past the 2 years of tax certificate issuance as of 9/1/2022? So how many do we have roughly properties?
We have around 370 properties right now. I know when August comes, we just published the 2019s, and that list is up to 470. So might be gaining a lot more.
So with that, if we go to in-rem and we bring a significant portion of the up to 470 properties, do we have the capacity there still is a due diligence before we take properties? That being an inspection of those properties, and maybe even to some extent some title work that needs to be looked at. Do we have the capacity, if we were to bring a significant number of that 470 to an in-rem position tomorrow? I guess that's a question for administration, because I know the health department gets involved to some extent, other agencies get involved. That's the question I have. And then, so I guess I'll start with that, and then I've got some additional questions.
Thank you. I appreciate the question. I'll probably defer mostly to Steve to start because, again, I think we last year instituted a process where we identified 50 properties to start with, and we had external resources that the treasurer's office worked to do that title research. And then I'll kick it to Mike to talk about if we did decide to go the in-rem route, we still have that title research that's done. We then have to identify the internal legal resources or the opportunity to go external and hire someone to take the lead on instituting the legal action and doing all the things Mike laid out orally today, and that's in your packet in that checklist. So my sense is that with all things within the treasurer's office, whether we keep using the current process of tax deed or whether we go the interim route, we're going to be better served if we bring in some additional external resources, or at least talk about how we might do that at this committee, because there is this large backlog. Moving forward, maybe next year we'll have the process refined and we'll be able to do it more quickly. But with that, Steve, why don't you talk a little bit about kind of what resources you have now, and if you had to address those 50 properties that we talked about.
Okay, so about a year ago, we sat with the county clerk, the health department, and Mike to address how are we going to handle the backlog and which properties to pick first. From there, we had several properties that already were tried through the tax deed process that the county committee deemed environmentally not sound to take. So those were excluded off the list. And then we went with a process to make sure we're excluding sliver parcels, things that will cost the county more than taking the property, and some legal issues with those properties already because they are unknown landowners and type deals like that, where title research is muddy, and IMREM will help on that too. But those were excluded from our 50. And then it went from a dollar value set, so above a certain threshold, and the oldest first. So we're picking oldest ones and that are of certain dollars or more on assessment value. By doing that, it eliminates a pick and choose method if someone were to come up to us and say, hey, why did you pick my property above someone else? Because if you start getting selective, you put yourself in legal liability. So by keeping a process in play on screening it, you have legal background. So that is what we would do, either tax deed or in realm, on how we're going to pick the properties. So that part would not change unless, we hear from the committee if we need to change any of that. I know the environmental screen, that is under the county ordinance 3.23, and that would take an ordinance change to get rid of that or keep it. So right now we're currently keeping it, and that's why we also talked with the health department on how much can they handle with their staffing, because they have to do that screen. And they said 50 to 100 max a year would be their max with their staffing. So that part could also get moved and outsourced too if needed. If you need to do more, we could outsource that portion and then add it to the parcel for expense. Is there any questions on the screening or how
Steve,
we
do you want to talk about, we have gotten some of those screened or done the title research. You want to give
Yes.
the committee an update as to kind of where we are?
So at that time, we had identified 50 parcels. We sent it to Runkel. They were our winning bid to do the title work. We had a couple different title companies involved on that bid process. So Runkel has been doing the title research on those 50. We gave also the 50 parcels to the health department to start their environmental screen. We have gotten about a little over half of the environmental screens done and almost all of the 50 title research ones done. A few have made their way off the list as they called and paid off their taxes. I think we have like 3 or 4 that actually paid it off. And we have a couple that we sent out letters to and getting ready to do a tax deed on, like 3 properties for sure. But a lot of questions even with the ones, because we are processing the oldest ones. We're finding that when we do get the title research back, some have like 20 or more liens on them. So you're talking like, if you're taking it, a lot of notifications, a lot of time was spent sending the letters out. It takes about a half a day just writing the first letter to send out per parcel. So, and then when you're doing that, you're sending out certified mailing, waiting a month, and if any of them come back not signed, now you're publishing in a paper. So when you're notifying that many people, the likelihood of getting all of them to sign is not great. So it usually equals publishing all the time.
Kurt, did you?
Yeah, so additional follow-up. So if I understand you correctly, but there's also the point of once the title work has been done, there's a time period where that's effective and still good, where we can actually take that property before we have to do additional title work and title search, because there may be new lien holders that need notification. So where are we at with the ones that have been title search work done and completed? Are we, and you've said several properties have been paid up, but we're in the process of being able to take potentially 3. But if all 50's title work has been done, are we on pace to be able to actually complete the process on those 50, and take those properties, or have some kind of closure to those properties being, through the process?
So we had, like I said, we had setbacks, a lot of it with the new finance program and staffing, because that finance program did take a lot of our time setting up the program, setting up teller, adding 110 county reseating people with all the multiple departments. All that time spent really stopped us from sending out letters, creating the letters, because the letters take about a day per parcel to get them out. So the title research is done, and it still speeds up our process because we still got that title research. We do have access to the track index and the government docs. So what you do when we get to it is you pull up the track index, was anything recorded in between? And we don't need to charge back because you're only going back as far as the title research was done. If it was done in January, you could look back and see if anything new was recorded. And if it was, you can add to that research work. It's a very relatively easy search on the track index with the parcel, and it's a relatively easy CCAP search as well for the judgments. So because you're not going all the way back from the start of the parcel.
Sure.
So.
So I guess, am I hearing you correctly that you need additional staff to be able to complete these 50 because of the workday process that we've been implementing? I guess what I don't want to do is lose sight of the fact that we've got 50 parcels that have got the title work done. We've got 25 of those through the process of environmental screens, and they're and they're obviously the oldest and sometimes most complex. But let's get those moving, I guess, is my thought. And if you don't have capacity in office, then let's find the capacity. And this, we can allocate additional resources from potentially the county's HR contingency fund to bring on temporary staff to be able to do that. But I think that regardless of whether we transfer to in-rem or not, we're making some progress on some of these properties. The other questions that I guess I have is the tax certificates that were issued on properties as of 9/1/2022, does anything change between that tax certificate and if we were to, so those now have a 2-year period. If we were to implement in REM on, does any of those that are sitting in the queue or that are delinquent now, does that change when they were, if they received the tax certificate prior?
So that does not change.
Okay.
Because the tax certificate is regardless of either process.
Either process, the tax certificate is a tax certificate.
Yep. And then the staffing question too, you did ask. I do know the finance program, we are finally getting stuff built, so it is starting to feel like it's starting to free up a little bit of time as things are starting to get a little easier, which will help us speed along, shift our gears towards getting those top 50 done. I mean, it would be probably, resource would be great to help us speed along, especially with the list we have. If there is available funding to do that, we'd probably need to get some approval from the administration and this committee to help us, especially creating letters and sending that out with the time being spent. It would help speed things along.
I guess then the last question I have is probably for Corp Counsel, and that is under the in-rem, under the current tax deed process, we send out notifications, or the Treasurer's Office sends out notices to all the mortgage holders or lien holders on the property that has been researched from the title. So the in-rem, does that eliminate the notification of those mortgage holders under the in-rem process?
No.
So that notification still has to happen prior to, so there's no, so the mortgage holder can't come back and say, I wasn't notified.
Absolutely. They're actually required to be notified as part of the in-rem court action. So it's another piece that we have to show that we've done for the court to actually transfer title to us.
Okay. Thank you.
Cody?
Thank you, Mr. Chair. I just had a quick question on the guardian ad litem process. Like, how is that set up? How is it determined what properties go to guardian ad litem? I know in my area, I worked with the treasurer on a piece of property where they couldn't find the property owner, and where does that fall?
So in speaking with Eau Claire County, their recommendation, taking a step back, I guess, when these in-rem actions get to court, it is one court case with however many properties. So it could be 10, 50 properties as a part of one case. What Eau Claire County does is they actually have one guardian ad litem appointed in that case for any properties or property owners who are not identified. So that guardian ad litem would act for 10, 50, however many properties are part of that case, instead of having one for each separate piece of property.
I can
Go ahead,
follow
Cody.
up. And then what would happen if that the process lays out where you just can't get a hold of a property owner? Does it then just move forward without a guardian ad litem? Is the guardian ad litem only for properties that doesn't have an identifiable owner?
That the statute says the guardian ad litem is for unidentifiable owners. So if someone's notified and they don't appear, or we publish notice and they don't appear, that will proceed as if they were there.
Just an observation. I think that there's a need for us to perhaps revisit the process and the assignment. I'm also a little bit, I'd like to revisit the Chapter 3 provisions relative to the environmental screen, because there's an all appropriate inquiry standard that is pertinent to private sale transactions. There's an absolute protection under Wisconsin statutes, and that's only good until you get sued. But then the all appropriate inquiry comes in, and I think I'd want to look at that in terms of whether or not we're truly accessing that exemption. There's a bona fide purchaser exemption under the federal law, and, do we have the right people doing it? So I think we could move ahead with the process by which we take the title. I think we might want to look at our procedural moves that lead up to that title that I think would get at some of Chair Gibbs' concerns and other things, but we could move along a dual track, and this would allow us to look at that option and put it in place and try to, if we can, streamline that process and deal with it. There do not appear to be any differences relative to the rights of the current title holder under either process. There do not appear to be any changes relative to other municipalities' interest in that property than the other process, and therefore it becomes the issue of how do we get rid of our backlog, and what's the most expeditious and fair way to do that. So I think there are, again, what process do we use, and then what procedures do we use to implement that process? And they're perhaps two different discussions, and we could move ahead with the process and later revisit the procedures, if that makes sense. Any other questions? I know we kind of threw this at you, and the original intent was to put it on for education purposes, but my comment was if we educate and we want to act today, if we put it on for education, we can't. If we put it on for action and just want to educate, we can hold it over to a future meeting. What are your wishes? Do you want to deal with it today, or do you want to contemplate and deal with it at the next meeting? Cody.
Thank you, Mr. Chair. One of the things I wanted to have before moving forward was we had this outline of what happens in Fond du Lac County. I was wondering if we could maybe at the next meeting and just move to have staff kind of adopt this to Marathon County, and so we can see how this would conform to our specific, policies and procedures, and then talk about it at the next meeting.
Kurt?
I guess I don't have a problem doing that, but I think the other thing is, I think you hit on several of the points that I think, still potentially get in our way of whether we use in-rem or whether we use tax deed, and that is looking at capacity and the process that we're using for environmental screens, because we've talked about, currently the health department's got limitations of the capacity that they have. So is the value, the question becomes, are we getting the value that we need out of those environmental screens or not? And then I think the other question that needs to be answered is capacity at the treasurer's level to be able to start issuing mass amounts of letters if we decide to go to in-rem and have capacity to take on. And so that we not only don't continue to go backwards, because we got to 370 and now we're another year later, we're back to 470. The fact is that means that we haven't really made any gain. And so I would like to see us make some progress on that backlog, and so that we don't continue to increase that backlog on whatever progress we made. So that leads towards the question of capacity, and make sure that we have the capacity in place to be able to do what we need.
So I would look to administration in light of Supervisor Hart's and Chair Gibbs' comments. Would you be in a position in a couple of weeks or a month to bring back the sort of the thought process on what our capacity is and what other procedures we might need to change necessarily to implement that? So it's sort of our eyes wide open approach.
Sure. And I'll try to provide a meaningful response. And we certainly can come back with a plan to identify how we can bring additional capacity to bear to address this issue, and diving in and adding some specific to Marathon County meat to the bones on the process of what in-rem would look like here. We can work on doing that as well. My challenge is, to your original question, Mr. Chair, about, do you want to have education here today or additional education later before you make your decision? as your administrator, from my perspective, there is no downside. I can't imagine why a county wouldn't at least have an ordinance, as Corp Counsel said, providing the option to staff to pick which route to go. If we identify the process and identify, I'm making up a number here, but 20 pieces of property, 20 parcels, that we say, hey, you know what, we think in rem would work here. We can come back and tell you that, and we can go through the process of getting that ordinance in place, which will take another month. Or you can move forward with it now, and we still need to follow the same processes that are set forth in statute for in rem. If we decide to go the process we've always used, which is tax deed, and we need additional staffing to do that, or we can rearrange staff resources as they currently exist to move forward, we can do that. But not taking action on in rem today and not moving it to the full board does keep that tool out of the proverbial toolbox that Corp Counsel has been referencing. And my easy button on what we're going to do is very similar to what Mike did and what I did when you guys were already talking about this. So we reached out to other counties to see how they did it. I would foresee if you do move forward approving in rem, we take the properties that Steve referenced. We have a list of, it sounds like about 25-ish that have both the title research and the environmental screens done. And we reach out to those counties and say, hey, does anybody here in your county, do you outsource it to somebody? Do you have a local lawyer that does that for you? What's the cost? And learn more about it. And maybe we can move forward with 25 pretty quickly. Maybe not, but I'm a perpetual optimist and I hope that's the case. So I don't know if that's answering all the questions you offered, Mr. Chair, but I really don't, after speaking with Mike a couple of times, I just don't see the downside in having both options available. As Mike referenced, Eau Claire County was someone he reached out to. I did the same. I understand St. Croix County recently made the switch as well to allow this process to be available. So it does seem like a number of counties are taking another look at it. I would certainly defer to Connie relative to her statements before that other counties are seeing similar experiences. I just know ours is something we need to bring some resources to bear because it's a significant number of properties.
Kurt?
Okay, with all due respect to my colleague, I'm going to offer a motion to proceed forward with in rem. Obviously, I don't see any downside to it with the notifications to property owners, the notifications to all mortgage holders, lien holders is still the same. Nothing changes there. In fact, that we have court's eyes looking at it. I'm still a little concerned about capacity, but with that, I still want to have another option because, again, we're sitting on 25 parcels that are, the title is done. So my motion would be to approve in rem process and move it to the full board for consideration.
Is there a second? Seconded by Supervisor Leahy. Any discussion? Supervisor Hart?
Thank you, Mr. Chair. And I do agree with that. I think my wanting to have the process adapted to Marathon County and kind of seeing that is because, to my surprise, I had a constituent who reached out and wanted to know this process, so I wanted to know more about the process. So I think that I agree moving forward is good because there's no downside. I still want to see that process laid out so I know it and I can share that with constituents. Thank you.
Any other discussion? If not, all those in favor of the motion to approve and recommend adoption to the county board will signify by saying aye.
Aye.
Opposed, no. That motion carries unanimously. And we would look to administration, again, to identify those procedural items going forward, but this would at least put another tool in our toolbox or arrow in our quiver, whatever your desire is. So, thank you. Next, we'll go back to 6A, disallowance of claims. Mary Jo, you're with us. They're before us. Do you want to give us an overview?
Okay, the first one on here is a claim presented by Al Steiner, who on March 1st, we got this in, and, or no, February 27th, we received it. And he did not give the exact data loss. He just said, traveling home the other day, he struck a piece of concrete about 30 inches by 35 inches wide on Highway 52, causing damage to his wheel or tire to his car. And he is asking that the county reimburse for his damages in the amount of $337. After doing some investigation with the highway department and getting a little bit more facts on it, it was found that this damage or hole in the road, pothole, if you will, there was no prior notice to the highway department that this hole existed, and unfortunately, this gentleman had struck it and had damage to his vehicle. But because of that, having no prior knowledge of the damage existing in the road, the recommendation from our liability insurance is that we have no liability, we have immunity because we have not had prior knowledge to act on the damage to the road, so therefore they recommend disallowance of this claim.
So this is a state highway which we provide maintenance to. Don't we have some sort of immunity by virtue of it being a state highway?
No, we assume the liability through the state contract.
Okay.
And it is a state highway, it's Highway 52, but with the agreement with the state, the county does assume the liability.
Are there any questions? What are your wishes? Kurt?
I'll make a motion to deny based on recommendations from our insurance carrier.
Is there a second? Seconded by Lemmer. Any discussion?
Mr. Chair, if I could just clarify, is that a motion to disallow the claim?
Motion to disallow, excuse me.
Thank you.
All right. Thank you for that clarification. That was the second's intent. Any other discussion? Not all those in favor will signify by saying aye.
Aye.
Opposed, no. That carries. You got to watch that guy and make sure that it's. Second one would be Second Look, Erie Insurance / Trent Clark.
Yes, this is a claim. That Second Look Insurance is a claims recovery company representing Erie Insurance. And their client, Trent Clark, they stated on September 7th, 2022, he was traveling on Highway Z, in which they stated the Marathon County Highway Department was paving or tarring at the time. And their claim is that the flaggers flagged this individual to travel through the construction zone, and his vehicle was sprayed with tar. So the notice of pending claim arrived in, I think it was October, no, yeah. And then they actually presented their actual claim that came through in January for the amount of $5,000, trying to find it here, $5,269 for tar damage. Again, with investigation with the highway department, yes, they were tarring or paving the road in that area at that time. Trying to pinpoint exactly where this happened, they said it happened around Highway X past Highway Z. The highway department believes they were there. They can't say for certain if they were there on that day. They believe they were there. But again, according to the presentation presented to our insurance, again, we have discretionary immunity because even though the driver may have been flagged to drive through the construction area, there was signage present, and there is no determination as to tell how fast this individual may have been driving, causing the damage. or even if they were not flagged through, again, there's a statute that applies to having prudent speed while driving through a construction area. So there's no exact determination how fast the individual was going and if the county was truly liable. So based on that, the recommendation from our liability insurer is to disallow the claim.
Are there any questions for Mary Jo? Mike, anything you wanted to add? You had that
No.
profound look. Any other questions, Gail?
How would one go about proving that they were flagged on? Because I know this same thing happened in the village of Weston, and Weston did pay the claim.
Well,
Mike,
If I could, I would just say, because this conversation involves what is potentially a pending claim against the county, I would advise it's not in our best interest to talk about what potentially would be the way to prove or disprove the claim. I think what this committee probably should just focus on is whether we want to go through with the recommended disallowance. I would hate to create a record that impacts any future litigation if it was commenced.
does that satisfy your? Supervisor John,
Thank you, Mr. Chair. I'll make a motion to disallow the claim.
is there a second? Second by Supervisor Leahy. Any discussion? If not, all those in favor will signify by saying aye.
Aye.
Opposed, no? No. That motion carries, but not unanimously. All right, approval of claims and question costs. Christie emailed that out for March. What are your wishes? It's getting into a readable format.
I didn't email it out until just recently, so if you do want to hold off to have more time to consider, I would look at postponing until that. You'll notice also it's in an easier to read format, but because we are catching up in Workday, there's a substantial number of checks that we're able to issue that we've been getting through. So there's that report is longer than I had also anticipated. So if you
Sure,
needed
Gibbs.
more time, I apologize for getting out late, but we are trying to work through the reporting for this month. We do have time with the consultant, so we are hoping to get things that are easy to read and help you understand Workday along with us.
I guess the one question I would ask from Christie, or maybe it's just a report how Workday is categorizing. It seemed that there was an awful lot of things that were classified under supplies, and it ranged anywhere from potential legal to you name it. But is that a category that Workday utilizes?
I'm going to take a look at the report itself so I can just let you know which one of the columns you're looking at. So are you looking at the cost center work tags?
Yeah, I can't pull it up right now. I apologize. I'm trying to get my computer to update.
There's three different ways of looking at what the expenses are. It's by fund, then cost center, and cost center is corresponding more closely in kind of to what you have as program or department. So in county finance, we have one cost center, county finance. If you take a look on the report, there's one such as CIP facilities, general government. Under that, there's also a category which is personnel, contractual services, supplies, fixed charges, and then under that are spend categories. And this doesn't go to the level of a spend category.
Okay.
Spend category would be office supplies, technology supplies, and that type of thing. So if it is something we want to break down further, we can always take a look.
Okay, all right, thank you.
Any other questions? If not, what are your wishes? Chair Gibbs.
Move to approve.
Is there a second? Second by Supervisor Hart. Any discussion? If not, all is in favor of approval of the claims and question costs will signify by saying aye.
Aye.
Opposed, no. That motion carries. Authorization of memorandum of understanding for opioid litigation settlements. I don't know if Kurt, Michael, who's going to take the lead?
I can take the lead, Mr. Chair. In your packet are the two memorandums of understanding that we're discussing today. This is all relative to the ongoing opioid litigation between us and most of the other counties in the state, as well as nationally as well. These memoranda would authorize us to move forward towards this opioid settlement with a portion of the covered defendants. So our representing attorneys have recommended this particular settlement be accepted. As a part of accepting the settlement and receiving the funds, we need these memoranda of understanding to allow the proceeds to be allocated to the county. We certainly, from my analysis and in my review of correspondence from our counsel, I think there's really no downside in this case to entering into these memoranda. We already have existing memoranda for previous settlements with other opioid defendants, so this would these mirror those types of memoranda that we've already entered into. This would allow the county then to move forward before the, I think, April 18th deadline that we have to submit these memoranda. So in my estimation, my legal recommendation would be there is no risk or downside to entering into these at this time. And if you have any particular questions, I'm happy to answer them.
Kurt?
Just so everybody also is clear that, states, where the state has already entered into statutes, how any proceeds coming into the state are divided. That is agreed at 70% will be apportioned to the counties and the several municipalities that were in the litigating group. And there is, in that, it also barred any future additional litigants from getting involved. And so it's spelled out that effectively out of this, this potential settlement here of about $20 billion, that the state of Wisconsin would get its portion, and then the counties would receive its portion based on that. So.
This is the next round of the settlements versus the final round, and not the first. So if not, what are your wishes?
Make a motion to approve and authorize the appropriate signatures on the memorandum.
Moved by Gibbs, seconded by Leahy, to enter into the MOU for opioid litigation settlements. Any discussion? If not, all those in favor will signify by saying aye.
Aye.
Opposed, no. That motion carries. Moving on to 6B1, acceptance of grant funding for Health Department anti-tobacco vaping activity. Lori?
Okay, thank you. In your packet, there was a white paper about this specific item entitled Jeweled Settlement Fund in Marathon County. So we are the fiscal agent. Marathon County is the fiscal agent to the Nicotine Prevention Alliance of Central Wisconsin, which is a tri-county prevention alliance that serves Marathon, Wood, and Portage counties. We did apply for a grant as a part of this Nicotine Prevention Alliance to address harm caused by electronic nicotine delivery systems. Some may know that as vaping. And it's considered a public health concern, and it does cause harm within Marathon County. So the Wisconsin Department of Health Services is going to receive this funding. It's $14.7 million over the next 5 to 10 years because Juul had to settle because they were marketing towards youth, or they were found to be marketing towards youth. So they did, they are paying a settlement to the Wisconsin Department of Health Services, and that's why the grant funds became available mid-budget year. So we are asking for funding to accept this funding in order to do these activities that are listed below, promotion of cessation activities, and again, the target population is under the age of 24, electronic nicotine delivery system disposal kits, because you can't just throw them out in the trash, and educational outreach to retailers and specifically. Does anybody have any questions?
Are there any questions? Supervisor Leahy?
Thank you. Would this primarily happen through the school systems, or are there other avenues to reach the youth? So there will be a lot of targeted messaging towards the school systems and the universities in these counties. Part of the funding, in fact, it's $15,000 of the funding would be for a targeted marketing campaign.
Any questions? If not, what are your wishes? Supervisor Marshall?
Knowing what the usage is there goals for, I mean, I know the goal is 0, but are there realistic goals for the outcome of the marketing campaign, that in 3 years you'll have not 16%, but say 10%?
So we, as Marathon County, have substance use and related goals and tobacco related goals. I don't have them offhand right now, but also this grant will have goals related to, you know, how much use the disposal kits will get, how many touches with our marketing campaign, things of that nature. But ideally, we'd want zero people vaping in Marathon County would be my ultimate goal.
Just picking up on Supervisor Marshall's question, it's the outputs versus outcomes. And I think, you know, if you can, within your performance metrics, look at some outcomes, because merely presenting or making kits available and doing educational performances doesn't, in and of itself, modify behavior. And it'd be nice to know if we had some success in actual reduction in numbers. So I would encourage you to look at all your metrics, including what the outcomes would be at the end of the day.
Yeah, we do have, as part of our community health improvement plan, we do have outcomes listed and strategies to meet those outcomes. So that would be part of those, yes.
You don't have the benefit of hearing me say that at the Board of Health meeting.
I appreciate that.
Supervisor Zhang.
Thank you, Mr. Chairman. I'm just reading here, and it states that each county would receive about $4,500 to carry out the work on college campuses. I'm assuming that there's still going to be efforts as well too done at the high school levels as well too. Is that correct?
Yes, there is.
And I guess I'll talk with you later as well too. Thank you.
Thanks.
All right, any other questions? Supervisor Hart.
Thank you, Mr. Chair. I wanted to know, is this so this is getting divided among the 3 counties because we're part of that alliance, is that correct? So it'll go to all the college campuses here in Marathon County, Wood and Portage, and then any other outreach throughout those, correct?
So there's going to be $4,500 to Wood and to Portage counties. We actually, a lot of our efforts for outreach would be underneath our existing tobacco funding that was approved by the board previously. And so the other aspects within the budget, so we do have program supplies, and that's about $5,675 of the grant. And then the remaining, of course, the $15,000 is going to be the targeted marketing campaign.
Any other questions? If not, what are your wishes?
I'll make a motion to approve the grant funding for the health department's anti-tobacco vaping activities.
Move to approve, seconded by Supervisor Marshall. Any discussion? If not, all those in favor will signify by saying aye.
Aye.
Opposed, no. That motion carries. Next is creation of section 2.02 sub 6 sub B of the Marathon County Code of Ordinances, election administration grants. Stacy or Supervisor Marash, did you want to present?
Thank you, Mr. Chair. So this is an effort to just create consistency across the board for applying for grants and accepting grants into the budget, because back in the 2020 general election, the Center for Tech and Civic Life furnished approximately $8.5 million to 5 Wisconsin cities, an additional $1.6 million to over 200 other Wisconsin municipalities. And Marathon County was a recipient of $10,000 of that money, and then 61 other municipalities each received $5,000. Now, many other counties in the state have chosen to pass resolutions prohibiting the use of private donations to administer elections, and that's not what I'm looking to do, because having a conversation with Clerk Trueblood, she used this money for very beneficial purposes for our county. So all I'm looking to do with this creation of Section 2.02 is to have all of the grants that become available be accepted through the board, like all the other ones.
Go ahead, Supervisor Hart, then I'm going to ask for any, go ahead.
It might be the same question. I was going to ask how our other grants are processed right now.
That was what I was going to ask Michael to explain.
Sure. So we do have an existing ordinance regarding grant funds. I'm just finding it. It's 2.02 sub 6.
It's in the packet.
It is in the yeah, it is in the packet. So any grant funds that are not provided for in the adopted budget are approved here at the HR Finance and Property Committee level. So this committee can approve grant funds. The next step, of course, is expending the grant funds. So once grant funds are approved and accepted, they have to be transferred to an account that actually allows them to be dispersed. That has gone to the full board by a 2/3 majority vote. What this proposed ordinance would do would be any election-related grant would need to be approved at the full board level. In looking back at those 2020 grants, I couldn't find that they had been approved either here or at the full board level. I don't know if they were in the budget or not, but this, I think Supervisor Marash's aim was to address that concern.
We have changed the rules. It's correct that we put this in the last rule revision package, is it not? So subsequent to that, we had the discussion at the Rules Review Committee relative to the acceptance of grants, and we wanted to make sure that there was A, board review and approval, and B, county board approval of the expenditure of the funds.
So the expenditure of the funds piece isn't in our ordinance, but it is state statute 6590. And my interpretation of that is that anytime we want to move the funds to be expended, it has to require that 2/3 vote. That's not in our ordinance, but that's how I've interpreted it. I can't speak to how it's been interpreted before I laid eyes on it, but that's consistently been how I've been interpreting that.
Chair Gibbs.
Well, if that's the case, and we've actually codified it in our rules that it is a budget amendment, and to be able to expend them, then this would be duplicative, would it not? I guess that would be a question. It would be duplicating the same, it would be putting into ordinance what we already have in our board rules.
So I think under our board rules and the accompanying state statute, the process should be that grant funds are approved here, the expenditure of those funds, so the move of them to an account that allows them to be expended is approved at the board level. This would change the way I read it. It would change that election administration grants would be approved and the expenditures would be approved at the full board level. So it is slightly different than the current practice, but I think your point about there is a mechanism for board approval is correct at this time. I don't know necessarily historically that it was followed.
Supervisor Hart.
Thank you, Mr. Chair. And then outside of that, if a grant were to be included in the budget, that in itself has to be approved by the full board. So no matter what happens, everything has to be approved by the full board. There is no mechanism for anybody to accept grants, but not expend those grants without approval of the full board, correct?
That is my reading of state law. So that my advice moving forward, and since I've been corp counsel, is that is correct. I don't know necessarily what was followed previous to me being corp counsel.
And the appropriate people are in the room with Christy as the finance director and Michael and others relative to the implementation of that policy. So other questions? Supervisor Marshall.
If it is state statute that requires board approval for expenditures, was that done in 2020?
No, that's been in place for a while. I don't know exactly how long, but before 2020.
I've had an opportunity to talk to the clerk, and she thought she was proceeding based upon discussions with the corporation counsel at that time, according to procedures. And I think what we wanted to do is make sure that that is understood, that was not our practice and won't happen again. Is that the best way to explain it? Sure. Supervisor Zhang.
Thank you, Mr. Chairman. One of the things I've seen during my time as a county board supervisor is that usually when ordinances and changes to our policies are being made, it should be run through the individuals, parties that are involved. I guess the question I would have for Supervisor Marash is, has this been looked at by the parties that's particularly, if the staff that's particularly involved, specifically like the clerk, Christy from the Director of Finance, and also Corporation Counsel?
I had a conversation with Clerk Chublet on the phone regarding the prohibiting the use of private donations to administer elections that many other counties did pass, where they're not accepting anything like that, and I didn't feel that that was in our best interest to prohibit that. So as far as Christy, no, I did not have a conversation with her.
Thank you.
Let me just tell you, this is not a new issue. Back in the 1970s, not to date myself, we had the discussion about whether the sheriff should take the grant. There was controversy about a motorcycle grant. And it led to the county board saying, you will not accept it because of concerns over liability and other concerns, and the sheriff went out there and bought it anyway. So it's an ongoing debate that took place, rest his soul for Louis Gianoli, but this is a discussion and debate that's been taking place. I think we now have the mechanisms with the new system where this will not occur and going forward. That's one of the advantages of moving beyond Kayenta and bringing in some of those institutional controls. Other comments or questions? Or
My only other comment, I guess, would be that my effort was to foster trust in our elections by providing additional transparency for what the grant funds would be intended to be used for. There's a lot of money being thrown at elections these days. We just had an unprecedented amount of money last week going into Supreme Court races. And so that was really the intent behind it, is just to provide transparency and help encourage voters to have trust and faith in our election process.
Supervisor Hart.
Thank you, Mr. Chair. And I just want to further say, there was a lot of money that went into last week's election, but that was on the campaign side. There is, and I've had this discussion with the clerk, there is a big distinction between the campaign side and how we administer our elections. We administer our elections in a incredibly nonpartisan way, and I know the clerk works very hard, and I've worked with her as the chair of a county political party in the past to make sure that those were administered in a way that both sides were very happy about it. And I think the clerk's done a really great job at that. I will, as far as this resolution, I can't support this because it seems redundant. And then to go further than that, I don't want to further hamstring the clerk's department for if additional funds will be needed I know it doesn't necessarily hamstring, but I just don't want to discourage that in the future. Thank you.
What are the wishes of the committee? What are the wishes of the committee?
I think that the goal of providing transparency is a good one. I make a motion that we accept the ordinance change on election administration grants.
Is there a second? Is there a second? Is there a second? The motion dies due to lack of a second. Supervisor Marshall has the right to bring that before the board if she wishes to, but there,
No, the rules say the executive committee.
or the executive committee, I'm sorry. Thank you for the correction. So, all right, we will move on to others. And I applaud the goal of having that transparency, but I'm also looking at your initial comments relative to consistency across the board. And I think we did hear some concerns. We read, as a member of the Rules Review Committee, we did spend some time talking about that issue on the grants, and I think there were concerns, and hopefully it won't, the board will be involved in those decisions going forward. All right, resolution in support of utilization of state surplus funding to offset supplemental payments, payment decrease for North Central Healthcare, really nursing home operations. It's from the NCHC Community Services Board. Lance, Kurt, I don't know who wants to take the lead.
Well, it's in your packet. It's on page 71. I don't want to belabor the point. I think you previously at your last meeting or the meeting before had information from Gary Olson about the change in terms of how the state processed those supplemental payments and those CPE awards and the significant impact that it had on North Central Healthcare, and by extension, the impact that it's going to have potentially, if not rectified at the state level, on Marathon County. And the reason for that, just for a little bit of history, is that the nursing home operation agreement that has been in place for, I hazard to guess how long, but as long as Mount View Care Center has been run or operated, I should say, by North Central Healthcare, calls for any deficiencies in terms of financial performance. The county has the obligation to make North Central whole. Because again, that's not necessarily the work that North Central was created to perform on behalf of the counties. It's not mandatory that you have a nursing home. But if you're going to have one, you have to run it in accordance with all existing rules and regulations, state laws, et cetera. So the resolution itself spells out the financial impact based on that supplemental payment decrease that North Central is seeing. You see the column on the screen now as it relates to specifically being borne by Mount View Care Center and by extension Marathon County. Those two respective impacts comes to just shy of $2 million. So this resolution is essentially asking for the state to return to its previous operation relative to those surplus awards and those CPE payments, not only for this financial impact that we're talking about, 2021, but also develop a long-standing approach moving forward that is fiscally sustainable at the state level, but also for local counties that operate nursing homes. You'll see that the good news or bad news, depending on how you care to look at it and characterize it, is that our experience is not unique. There are more than 20 counties in the state of Wisconsin that were impacted in a very similar way. But regardless, however, it's a very serious impact. And as is spelled out in the resolution as well, we budgeted, North Central budgeted, the county budgeted, assuming that those payments were going to come in. And as of right now, they are not going to come in absent some change at the state level. And with that, I certainly, if Chair Gibbs, who also serves as the chair of the North Central Healthcare Executive Committee, and the full board, the North Central Healthcare Board can add additional detail.
And I think the administrator laid it out well. I think the reality was that, DHS had communications. We had an increase in our Medicaid and Medicare reimbursement rates, and were not made aware that there was going to be, and historically over the past several years, there hadn't been any changes to the supplemental payment that came to the county. Just a little side note, the supplemental fund that the state has is a fixed dollar amount that's allocated to all of the nursing homes that counties operate throughout the state. And again, historically, at least over the last 4 to 5 years, those payments have been pretty much fixed and unchanged during that period. And then, unbeknownst to NCHC, after we were notified that and hadn't even formalized the increase in the Medicare and Medicaid rate, we were notified that we were going to lose almost unrealistically, unbeknownst was an amount almost equal to the Medicaid, Medicare reimbursement rate increase was a decrease in the supplemental and excess CPE award were decreased. So those decreases almost equaled the amount of increase that we received in the Medicare, Medicaid reimbursement rate. Also, as spelled out in here, there was 2 counties that received a substantial increase. One, that being of Dane County, and the other being, I think it is Rock County, received a significant increase. And in discussions with multiple representatives, trying to figure out what was the contributing factor to that change. But this is asking for, and the NCHC board unanimously passed the resolution. So it was suggested to be forwarded to Marathon County for its consideration, and also forwarded to Lincoln County for its consideration, because the other nursing home that's being run by or operated by NCHC or administrated by NCHC is the Lincoln County Nursing Home Pinecrest. So they also received a significant decrease, as you can see on the payment schedule. So I would be very supportive of passage and forwarding this to all our area legislators. I've had that discussion with area legislators, and they're in support of looking at where there's opportunities.
Any questions? I know there is support for this among our area legislators. Today I was in Madison for the County Ambassador Program, but also in January, we specifically raised this issue with them, and there's an understanding of the consequences. And Senator Mary Falkowski, who's a member of the Joint Committee on Finance, is very concerned about this, given Pinecrest as well as Marathon County. So I think that resolutions like this may help in the effort to try to bring the nursing home operations near the black or less in the red. Cody.
Thank you, Mr. Chair. I think this might already be implied, but I just wanted to ask, the intention here is to have this included in the passage of the upcoming state budget, correct? Is the restoration of this funding within that budget?
I think there's 2 approaches that they're being looked at. One is a potential change in the budget and the allocation and directing, but the other thing is potential a separate piece of standalone legislation to fix it.
Any other questions? If not, what are your wishes? What are the wishes of the committee? Chair Gibbs?
I'll make a motion to approve. And just a side note, after, if there's a second.
Is there a second? Second by Supervisor Hardy. On discussions, Chair Gibbs.
Just also, if this were to come to fruition, this would fulfill the additional request and backfill that request. So that request from NCHC to backfill the losses would go away, at least for Marathon County. It wouldn't 100% eliminate the deficit at Pinecrest, but it would go a long ways in fixing that problem.
Any other questions or discussion? If not, all those in favor of the motion will signify by saying aye.
Aye.
Opposed, no. That motion carries unanimously. Acceptance of funding, $78,300 from the Department of Energy Efficiency and Conservation Block Grant Program. Chris.
Thank you, Mr. Chair. So this is a grant from the Department of Energy that Marathon County was notified we are eligible for in the last couple of months. And after digging through all the materials, I can say that I think the primary thing we're looking at today is just to kind of get the committee's approval to move forward with what they're calling the pre-award information sheet. That doesn't necessarily accept funds, it doesn't allocate funds, but what it does is it says, hey, we're interested. And so that's due at the end of this month. If we were to put that in, then what that then tees up is a process where we would want to say, to identify a project that meets all the different requirements, and there are quite a few with federal law and all these other things that you'd want to make sure any eligible projects we came up with would fit all of those. And if we found one that fit, then there's 4 application periods, and for us, we would most likely fall into 3 and 4, which essentially gives us until the end of January 2024 to submit an application saying, here's what we want to do, and to get approval. And there are 2 different approaches to this particular grant. One would be more of like a straightforward grant where with a lot more, I'd say it's more of a headache in terms of reporting and going through the process. And then they also have a voucher approach where you could get voucher to reimburse or to identify what you'd like to get reimbursed as part of a project. And so initially, there's nothing for us to do at this point outside of that pre-award information sheet to get that done. And then in the next several months, or we can look at that as a part of the capital improvement planning, or just in general to see if there's something else out there that might fit the sorts of things that they're making the funds available for. I'm certainly happy to answer any questions if people have any.
Supervisor Jones.
Thank you, Mr. Chairman. I guess my question is that just working with block grant dollars in my work occupation here, they tend to be very documented orientated as well too, and there's a lot of busy work, I call them, as well too. Do we have the capacity to actually do that as well too? I mean, working with a federal level entity seems to be, their documentation is just tremendous as well. So I guess I'm just kind of curious about the documentation and whether we have the capacity for that as well.
Yeah, it's a very good question. Excuse me. If you went through the traditional grant approach and the funding that we were eligible for was more significant than $78,000, then I think you really get into the area you're talking about where it becomes a lot of busy work, gets to become more of a headache. The voucher approach is, even based on what they've put out to date for application materials, is far simpler in terms of approach. And so even if you look through any of the materials associated with it, the lion's share of the paperwork has grant only. So if you went for voucher, none of that really applies. And the amount of funding also kind of narrows the scope in terms of what you can do. And then if we did have a project that we went through that we identified, and that would then come back to you and the board, obviously, per previous discussions and just in general, for getting approval for the project, then there's a 2-year process for the reporting piece of it. But since it would be essentially or most likely a one-off kind of thing, if you submit the application and they awarded the funds, then the amount of reporting you'd have to do would really just be the first time you submit what you've done with it.
Go ahead.
Thank you, Mr. Chair. Is there any matching funds that is required at all?
Good question. No, there are none.
Thank you.
Supervisor Leahy.
Thank you, Mr. Chair. More of a clerical question then, I guess. Does the agenda item need to be amended since we're not technically accepting funding at this time? And is this something that we even need to have an agenda item or something that needs to be moved forward to the full board? Or can this just simply be an approval at the committee level to?
Yeah, I think based on where you're going there, I think really if the committee were to give us direction to continue with the pre-award application,
That doesn't commit us to anything, but we can get that in. And then even if we didn't identify a project, there's nothing after that either. It would just be funny we never asked for. So nothing needs to go to the board. There was no resolution accompanying this because essentially once I started really digging into all of the paperwork, it became pretty clear that at this point, without an identified project and given the timeline, it was really more of a signal from all of you that you're interested and you'd like us to at least kind of indicate to Department of Energy that we might have a project that fits all the different guidelines. And then if we did, we'll bring it back through.
So I would look to Michael for legal clarification as to where we are with this in light of our previous discussions.
Sure. So this was agendized for action, which I think what Deputy Administrator Holman is looking for is direction on, do you want me to keep moving forward with this? If
A statement of intent?
A statement of intent sounds great. If that's your intent, then, right, I don't think this goes any further than the committee expressing that intent by motion or by unanimous consent.
Supervisor Leahy.
Well, based on all of that and taking into consideration staff time versus actual grant funding allotted, I would be in favor of a statement of intent to move forward with the process to be reevaluated at a later time.
Second.
Any discussion? Administrator Leonard.
And I'm going to say something you probably already know from serving on other committees. We do this frequently with other committees. I know Supervisor Marash is in the back. We just did this at Public Safety with a couple of grants. Kind of to your earlier conversation, we're really, as staff, making an effort to be very transparent. There are a lot of grants that are available, which is great. You know, it gives us the opportunity to seek out funding for stuff we are already doing to mitigate the financial impact to the local taxpayer to use, to essentially supplant funds we would otherwise use. So that's what we're looking for here. Very similar to what we do in other standing committees of jurisdiction. You, as the HR Finance and Property Committee, are the committee of jurisdiction for facilities because it's property related, and you're going to be looking at some more property in your next item. So that's kind of context of why we're here. We do this if it's a grant at the sheriff's office, we bring those to public safety. The DA's office just brought a grant to public safety, so a very similar approach, consistent approach to all your other committees.
So we have a motion, a statement to support the intent to apply. Any discussion? If not, all is in favor will signify by. If not, all is in favor will signify by saying aye.
Aye.
Opposed, no. That motion carries. Support for operational plan for future use of Lakewood Drive Campus A and B buildings. Continuation of our discussion from the last meeting with embellishment from Deputy Administrator Holman or Leonard.
No, that Chris printed the stuff out, so that's. I'll be very brief. There's a resolution in your packet that kind of again supports us moving forward with the concept. And I gave you a presentation previously, and I'll put it up on the screen again, but thank you to Deputy Administrator Holman for making some revisions, and he's handing those out to you today that kind of talk about what we're doing with the space. Again, the space we're really talking about, the A and B buildings, are set forth in your packet on page 76, and it's in front of you. Thank you, Chris. It's in front of you today in hard copy form. But essentially what we're talking about is continuing that movement toward what in your resolution is referred to as kind of the two-campus model, at least generally speaking. We certainly have more than, we're going to end up still with more than facilities located at two locations. But it's really seeking to consolidate our footprint. And I'm really talking about, again, the relocation of social services, which was already previously approved, and in fact, social services should be fully completing their move by the end of this week down to the campus. And again, that's located on that page 76 in the packet or the page in front of you in the light blue. But today we're talking about moving that, continuing in that process toward that consolidated campus model within that red square that's at the top of the page before you, and again, it's on page 76. So the modification, I want to be very transparent with you from the last time I spoke with you, and that was virtually, is that we've relocated the Veterans Service Office from that bottom half of that sheet into that red square. You'll see them kind of right in the middle and in that purple color, and that's to make some better use as we further evaluated their space at the lower portion of the document. And we really think there's some good opportunity, some good alignment with the ADRC and moving forward with their relocation as well as adult protective services into that middle area. And it also allows for some use of the previous space that they were going to occupy in the lower half of that drawing by some partners of social services that'll align nicely. So that's really the most significant change since the last time you've seen this document. The only other change is that we've gone through the process that is alluded to in your resolution, where we started the process of having individual departments really sit down with facility staff and Chris and the architects to do some space planning to kind of further refine what space is really necessary when we talk about repurposing that space. So you'll see not only the ADRC, that's really someone that's currently located, as you all know, and I referenced this last time. They currently rent from a third party. They're located on Stewart Avenue, South Stewart Avenue. Conservation Planning and Zoning, you'll see, is kind of the lion's share of the middle area in that darker green, currently located on River Drive, talking about relocating them along with UW Extension from River Drive to that A and B campus, along with relocating Veterans Services from that River Drive location, really taking the vast majority of departments off of River Drive. The only one that we would still be talking about and we're working on developing a plan for at this point is Parks, Rec, and Forestry Administration. When that's completed, you'll have that whole parcel, those parcels of 210, 212, and 327 River Drive to talk about what does redevelopment look like. So it really is a substantial step forward in terms of campus consolidation. And I also referenced last time the idea that HR, administration, and finance could be relocated to that campus in substantial part. We still want to have a presence here at the courthouse, essentially. Our thought process there is it's really important to have an HR presence, HR and administration primarily, finance less so, but HR and administration for sure at our two major campuses. You know, that's something right now that we don't have. We have social services had been on Thomas Street. There wasn't an administration presence, generally speaking, there. There isn't one currently at the Lakeview Drive campus. With this consolidation, we'll have a considerable number of employees at each of these two locations, which from a finance, from an HR and administration perspective, allows a good opportunity for us to have kind of a more of a presence at that location. We can ratchet back our presence here because right now we're entirely located at the courthouse. But in concept, that's what's before you. My hope is that the plan wouldn't substantially change, and I don't foresee that happening, but I'm sure that around the edges, there will be tweaks to the lines on this document aren't set in stone for sure. But at this point, I can give you my perspective. I think it's a really good plan. This is coming together. You know, the vision that was laid out in 2017 and 2018 with your Lakeview Drive renovation and the North Central campus renovation really is allowing for in substantial form, and quite honestly, more so than I initially envisioned even back then, of that consolidation. It's a pretty substantial consolidation. I think the departments that we're talking about relocating there will fit well. The social services move has gone to this point very well. The staff are expressing a great deal of satisfaction with the move and with the new space, and I think the same will be told for the departments that we're talking about. The only other piece I want to be very transparent with you, and I was transparent in the last meeting, specifically calling out kind of that, for lack of a better, and I'm poor with colors, but orange color, kind of to the right side of that red box. That is space that a number of years ago, quite a number of years ago, was utilized for a child care center. It's not being used for that now. It's an outpatient or community treatment is the actual term. Community treatment for North Central operates out of that space. But our belief is, and walking through that with a local child care provider, that could be repurposed relatively easily to be reutilized for that. We are aiming to do minimal renovation to any of these spaces, if at all possible. And that would be true for that space as well. But to the extent we can perform the renovation in a way that makes it useful for multi-use general office space, but also easily utilized for a child care provider, if that's something, again, based on this committee's discussions, that we can partner with a private or nonprofit to operate that on campus and help the broader community with enhancing the number of childcare slots. We're evaluating the possibility to do that. If that doesn't pan out, again, it's going to be renovated in such a fashion that it can be used for just general office space, and we certainly can modify those plans in speaking with this committee and the full board. But that's the plan before you, and the action that's envisioned today is if this meets your if it has your continued support, the resolution would go forward to the board. But happy to answer any questions you might have.
Supervisor Jean.
Thank you, Mr. Chairman. Just a quick question for administration. Typically, when it comes to capital projects, especially my role here, I want to make sure that we are setting ourselves up so that way we can stay there for 30 to 40 years, or even more as well too. The current design, is it going to set us up for in a way where we are able to expand if we have additional staffing, et cetera, as well too? Just kind of throwing that out there. I know you mentioned there's some empty spaces, but I know that there are some other departments that may be growing in the future as well too. So I'm just kind of curious.
Yeah, that's a great question. Based on the information we have right now, I think this plan does set you up for any future expansion that we can plan on, that we would foresee. The flip side of that coin is that, we're working a lot differently, and I brought this up relative to the social services relocation, the opportunity to actually continue to consolidate space. We have staff doing, there's more hybrid work, and if you went through the tour for the social services space, that is again on the document before you, it's substantially smaller than their current footprint. The other thing about bringing more departments to a single campus is that you can have fewer shared spaces because they're available on a single campus. I talked about the conference room space that will be available, and it's on the document in front of you, that kind of purple at the bottom right corner of that document. We don't need to have a whole bunch of conference rooms and shared spaces available within each department footprint. We can have them close to that department and have multiple departments make use of them. So the short answer to your question, I think yes. I think we have enough flex space that we can accommodate additional growth. And at the same time, I think this space, we can also make some changes to how we work, and we've been doing that. Quite honestly, that's a silver lining of the pandemic. It caused us to look at things differently, not only within the departments I mentioned, but even in this courthouse. Court fundamentally changed. So I think the plan, as the facts we have right now, as they exist, I think is a very strong plan. I don't know, Chris, Troy, if you guys have anything you want to add on that question?
I just say I would stress that this really is a continuation of multiple other projects. So in terms of longevity, the roof is currently being redone. A lion's share of a project that was previously done in capital improvements was for HVAC upgrades, bringing up the sprinklering to code and things like that. So you're really bringing that building from original construction up to modern times, from soup to nuts, really. So you're really positioning yourself structurally for the long term. And then, as Administrator Leonard said, there is some flex space in there. One potential thing would be if we're centralizing finance down the road, there could be adjacent space made available. even potentially where facilities and capital management is currently located, that, that could potentially down the road be an opportunity to move out of there into an adjacent space and free up additional footprint for somebody to come down in the same neck of the woods. And I'm not sure if Troy has anything else.
Just a follow-up, Mr. Chair.
Go ahead.
I guess the other, and I'm supportive of the consolidating our departments. Only other thing I would have concern, and I don't know if this would be the right place to talk about, is traffic in the future here as well too. But I'm sure that's already a discussion as well too, or that's on their plate here. But that's all I have. Thank you.
Yeah, I can touch quickly on that if you'd like. So in terms of traffic capacity, we're going to be beginning the demolition of one of the buildings on campus. That's actually got an X through it on the other side of the page there, and that will free up approximately 140 parking spaces. So once that's done, you'll have nearly 1,000 parking spaces, and a lot of, whether it's social services only using them from time to time because they're doing remote work, or you have people coming and going through the aquatic center, those spaces is plenty of capacity for projected use. And then I've got a meeting set up with Metro Ride to talk to them about how the bus can work through the campus especially after North Central departments change their current location. And then we're also working on wayfinding and things like that from different approaches to the campus. And so we're trying our best to accommodate those types of questions based on a location, moving forward.
The only thing I'll add, I think that's a great point. I mean, parking is a big piece of traffic. The other thing I think is it's been helpful for me to learn more about the history of that campus. The nursing home that we have today, or that we will have in the future, is a substantially different nursing home than the one that was there 20 years ago. And I'll defer to Chair Robinson on the specific bed numbers that were there. But my recollection, over 400. We've had a nursing home that had a license of over 400 nursing home beds. Now we're probably looking at a census that we're aiming for around that 150 when all things are considered. At the same time, we previously had a third party that rented space from us on a building that you can't see. It's on the other side. It's that kind of the darkest building in the back corner, the Lakeview Professional Plaza. They no longer rent from us. I mean, they had a number of employees, took up more than a floor and a half of that building. So I would certainly say my belief is we're not substantially increasing the number of people coming and going from that campus than what we're coming and going from that campus historically. That said, it's different people. It's more county staff, fewer North Central healthcare staff, far fewer nursing home guests. We're not having the Inclusa employees that I referenced before. That was that third party. Or the people that were going to Inclusa to meet with them. So I don't see a substantial increase in terms of gross traffic, but it is different. And we've been, when you make your comment, one of the things that I think about is how do we do the community outreach to make that clear? And we've been very engaged with that local southeast side of Wausau community. They have a very active neighborhood group, and I am certainly attending those meetings, and I do so from a self-preservation standpoint. I live in that neighborhood. So if they were not happy, they would not have to walk far to come, not happy or not well-informed, they would not have to walk far to come to my house to make that clear. So we've been, I think, very forward-thinking in that sense and trying to engage that community to make sure that they're aware of those things, because it does look different, that campus. And if you haven't been down there, we'd invite you to come down and look at it. We're very excited about it, but it does look different.
Supervisor Hart.
Thank you, Mr. Chair. And we've been talking about the external wayfinding. I wanted to know more about the internal wayfinding because a lot of these services are very important, and people are coming here to get important things done. I just wanted to know about the navigability within this space. in terms of reception desk and wayfinding signs and anything like that. If someone needs to be able to know where ADRC is, they can find it immediately as they walk through the door. Same thing for veteran services. That was one of the questions because it kind of got moved to that back and you answered that, but it was previously like right when you walked in the front door at the social services building. So I just want to make sure that people are able to find those services immediately when they walk in.
Great question, and I'll kick it to Chris I'll start with from the start of this project back in 2017 and 2018. If you've been to North Central Healthcare, I don't care how many times you've been there, you probably get lost if we ask you to go on to try to find something. But one of the big goals that started this process is the consolidation of the number of entry points for the public. And you really do see that even on the portion that I'm showing on the screen, page 76, or what's in front of you. If you look on kind of this large footprint, you'll see that the number of entrances, and Troy probably knows the number of doors that we used to have, but I mean, I want to say it was like 70-some doors that people could come in and out. 72 doors. See, I was close. And we really, through this design, this five-plus year process, one of the guiding principles, public goes to the front and enters through the front through a fewer number of doors, and staff entries are more around the back side of this building. So I think that, to one of your points, finding where you need to go doesn't just start once you get into the building. It's how many entries are there? It's the signage on the exterior of the building, and Chris can talk through a little bit of the process, but we actually just met, is that this week or last week? Last week?
It was last week, yeah.
Last week, Friday, talking about what does that look like, and we have temporary signage up right now. We want to make sure we do it right. So let's get a final plan, get people into their spaces. But Chris can talk a little bit about the conversations we've had and where we're moving.
Yeah, so essentially, I mean, the exterior signage is important in the sense that there's really the two main entrances to the campus. And so right away you can direct people Marathon County to the left essentially and everything North Central to the right. And then the next kind of layer, if you will, moving in are the parking lots. And so once everything's done, you'll have lots A through K. And so that's another point of reference that you can tell people. If you're going to the tower, then you should pull into lot B or lot C, and then that gives them another direction after so they've got the first sign, then they have a lot, then they'll have signage right outside each door highlighting what's inside of there. And then between the county and North Central Healthcare, even though the internal wayfinding will be, what I'm trying to say is there will be consistency in terms of font, approach, what we're using, and if it's a door tag, if it's whatever it ends up being, there'll be consistency across the board so that people aren't confused by different types of signs. And we're also looking at temporary signage to make sure that the signs work where they are. So if people are getting to where they need to be with the temporary sign, great, we can do something more permanent there. If not, then we can adjust where that sign goes and then kind of test that out over the 6 months or so once people have really moved and we've got a good sense of how that internal traffic works. And then within each department, you're going to have a sign out front highlighting who they are. The hallways, again, will have signage throughout. And North Central does get a little complicated at times in terms of finding your way from one place to another because there's just a lot more going on there. But that being said, generally speaking, most people are coming there for a specific purpose. So once they've kind of got through that initial wayfinding to whichever part of the agency they're working with, then it'll become more rote in terms of when they revisit the campus. And so it's we've had multiple meetings. The last meeting provided some good focus in terms of both external and internal. But at the end of the day, that's definitely one of the key points that we're looking at now that we're at the point we are in terms of the overall campus being close to being completed.
The advantage of this is that instead of driving around town looking for the different locations, they'll be in one facility. So that is a significant benefit in the terms of coordination because people aren't always sure which programs will benefit them. And I think that there are some significant improvements in customer service and our ability to deal with their needs. Supervisor Jean.
I was going to make a motion to approve the proposed operational plan.
Is there a second? Seconded by Supervisor Lemmer. Any discussion? If not, all is in favor of the adoption of the operational plan will signify by saying aye.
Aye.
Opposed, no. That motion carries. And I apologize for not getting something out to you relative to TIF. I'm still working on it, but here, and because of the time, I'm going to just throw this out and we'll put it in writing. What I'm hoping we can do is have a charter that will ask for a review of the current TIF law. What is its background, purpose allowed? What have the changes been over time? How are taxing entities treated under tax increment finance? How does it impact the Marathon County budget? Who represents us on the joint review board? What are the powers of that board? And then get into an evaluation of TIFs in the county. What is the current status of TIFs, number of TIFs, valuation increases of TIFs, donor versus regular TIFs? What was the purpose of the TIF? And did they follow the but-for argument or requirement? But for the creation of the TIF, it would not have occurred. How many have asked for extensions in their period of time? How many years have those extensions been for? How does the original TIF plan compare to the performance of the districts in terms of what was promised versus what delivered? And then we'll get into what is the role, what is the county's role in how do we play, how does that compare with other states? I think it would be important to have that. What role should the county have in the use of donor TIFs, extension of TIFs, exceeding the valuation requirements, and then expansion of scope on the TIFs. And within the discussion, we'd also look at the benefits of TIFs and the issues associated with it. If that seems to be following what you wanted to do, we will present that in writing at the next meeting. Gail.
Thank you, Mr. Chair. I just had one addition that if we could look at the tax impact on our constituents, and know that there's a tax impact to the county budget, but there's also a tax impact on the people we represent. Thank you.
I think that would be implied, but that's an embellishment that would be worth noting. Yes.
Yeah, one other thing, thank you, Mr. Chairman. I think the other thing is, we have representation on the committee that reviews the planning committee. So is the representation what we want, and how do we interact with that representative on our recommendations for vote, and what process should we be using?
Any other? All right, we will bring that forward. Next, we'll move on and amend the 2023 capital improvement budget for the Marathon County Jail Kitchen Project in the amount of $64,205 for Phase 1. Chris.
Thank you, Mr. Chair. So I put together a memo on this one to try to provide some context for you in terms of what we're asking for and why. So when I say Phase 1, that's really looking at sort of the initial design and getting to a schematic that allows you to get to a point where you can start getting cost estimates for the next phase of the project. Generally, I mean, in summary, what occurred was that we lost our vendor for providing the jail meals earlier in the year, and so we made a pivot towards North Central and tried to make that work. There were some discussions about, expanding their kitchen perhaps to have the capacity to meet those needs. And then as we started contemplating other ideas, looking at what that would cost and looking at the impacts of North Central, because they have their own sort of requirements, which are not exactly simple and straightforward. It became pretty clear from a space situation, but also personnel, and also just the transportation piece of moving those meals from North Central to the jail, that we should look at other alternatives that would utilize the jail kitchen, the scullery currently, to make the meals on site there. And there had been a kitchen previously, or more than what's there now anyway, and we recently completed a HVAC project in the jail which actually was timed up nicely for us to kind of make sure that that tied into the use of this space for what we're talking about here. And so phase one, if we've got the architect on board for that through a RFP, that's the amount that's in front of you today. And then phase two would come back to you for the cost estimates based on the construction and equipment needs. And then I know that jail staff will also be working on an RFP to find a long-term vendor in that space. Longer term for a number of different reasons, but definitely because the county is making an investment back in that space to have a vendor come in ready to take that on and be able to provide up to 800 meals a day if needed. Currently, it's closer to 600, but we wanted to make sure that that capacity was there long term. And so we're in a good spot in terms of the overall shift and finding a long-term solution that's sustainable and viable. And then once we get to the next phase, something will come back with funding requests to do the construction work, and then concurrent to that will be the vendor. And if we can get that done, kind of in the near future, then that vendor could come online as part of that final construction process too, and help inform the equipment needs, help inform the space needs and things like that. So lots of different folks working on this. There's been multiple meetings in terms of how do we work this out in a way that is, like I said, truly viable and sustainable for the long term. But this is essentially step one, which one gets funding for the first phase, but also creates a project in KIP so that then moving forward, as costs associated with the project, they have somewhere to go within our financial system.
Are there questions for Chris? Chris, I have some questions, and I'm a little bit concerned because there seems to be a ping pong ball that has been out there, and it's gone from do it in-house, North Central will do it, we'll do it in-house, we'll do it with a private party, and that ball's been going all sorts of directions. Now we're being asked to approve a design plan that gets us into potentially a locked position relative to the future. My concern is, do we have a business plan, and have we articulated what the business needs are relative to the investments, and have we looked at our options that are available to you? Because once we put that money into the kitchen, we may own it, but we may not use it if the vendor wants to deliver services in a different manner. So have we sort of explored all of our options? And I understand we're in a difficult situation, but I don't want to get us into a position where we make an investment and we don't use it.
Sure. I'm not sure. I'm not sure there are a lot of options from my point of view. I think that North Central, initially it was a good idea to look at that to see are there ways to spend the money internally? Are there ways that would they have the capacity to take it on? But I think once you were looking at the changes they would need to do in order to try to staff it and do the actual meals there and get the transportation done right, then that brought up questions about, okay, well, what's an option that, if you're going to spend that amount of money, what's something that if you were going to operate it, then you could do it in the jail, and you're removing the same concern we have now in terms of transportation. Similarly, I think North Central, initially the costs have gone up. A lot has changed in the last year or two, and I know it's been changed, has been a constant since COVID and everything else. But I'll say that part of the idea behind moving to a kitchen is to do it in a way that is inclined towards what a vendor would need to operate in that space. But I think long term, if some vendors, let's just say there were no vendors that could do it, you would still, then your staffing issue would be the primary case, but everything else would still be there to produce the meals on site. Because transportation is a bigger factor than you think in terms of just moving even from North Central to here. And it was coming from a longer distance before, but those cost increases, at least a portion of them, seem pretty unreasonable from the county's perspective, which kind of kicked off the initial conversation about how else can we do this. And then once you started looking at even North Central staffing, and I'm not, obviously I work for Marathon County, but knowing the world that they're in, I think you wouldn't want to have nursing home needs competing with jail needs, right? So that's part of that difficult situation you're alluding to. And North Central's perspective is that they're going to have to really focus on those, and rightfully so. And so and they, along with others, they have staffing challenges. So if they have a staffing challenge and they lose a cook, who are they cooking for, themselves or us? And so again, that's where the vendor comes back in. Not that vendors don't have staffing issues, but that's back to that longer term contract piece too, where if you have something that's situated for the long term, then part of bringing that vendor in is with the intent that that's going to be stabilized for a much longer term than we've typically had in terms of our relationships doing this service for the county. And I'll say part of the price increases too, there were increases for things like portion size, because the nursing home portions are different from a jail portion. And obviously the customers are different as well. And so portion size is a major factor from the jail population, and so you want to make sure you're meeting that. But what I'm trying to say is that even when we looked at the initial costing, the challenge on portion sizes added additional cost too, which then pushed us to look at how else makes this more feasible for a longer term scenario that doesn't interfere with North Central operations and still puts the county into a position where even if it's investing the same amount of money, you're not generating conflicts between the agencies. And so I think if the kitchen moves forward, then you really have the option of running it yourself or having a vendor. But the vendors are most suited to doing that, and the vendor relationship that we had previously wasn't part of the overriding concern with the cost increase, from my understanding. And so I think that the ones that we know of that are out there would still be interested in working with the county once we, moving this project forward. So the other part of the urgency and the 600 meals is that, like, again, back to staffing, if North Central couldn't do it and didn't have, or lost staff and they had to shift their focus, then what's our situation then in terms of producing those meals on a day-to-day basis for the jail population? So there's, I guess, at the end, there's no nobody wants to be in this position, but once we were in it and once we started finding the challenges along the way through our conversations and realizing the full impacts in North Central and then the full costs that we were looking at of doing it that way, that's what pushed us back in this direction to not ping pong anymore, to your point.
But my concern is that you talked about bringing a vendor in. Does the vendor want to work in their kitchen or your kitchen? And so from a design and efficiency perspective, doesn't it, have we explored an option, for instance, doing a long-term contract where they would make the investment in the kitchen and a payback to, we would cover it through our meal cost? Because then it gives them the creativity and the opportunity to design the kitchen for their needs.
We asked that question, and they want to work within a storefront or their own or a kitchen, but it's easier for them to work within a space that we have versus they'd have to have a site somewhere else, and then the transportation becomes their issue too. And so that's why.
But couldn't we lease our space to them and have them do those improvements?
I guess in theory, but you'd have to have a vendor who's willing to invest their own money in county infrastructure, which I think would be a challenging proposition.
And if I could, ignoring the public work restrictions we have about other individuals making improvements to our buildings, what's going to happen is they're going to do the improvements and they're going to charge us. I mean, our contract cost is going to go up. This is my overly simplistic view. The struggle we have is right now we have limited options. Worst case scenario moving forward, if we do this, move forward in this direction, is that we have a kitchen space that in the future we don't utilize for delivering meals. And I would love to get to that point. But that's because that's the least problematic problem we could face. The problem we have now is we have no control over our own destiny of how to deliver these meals. We had a vendor who quoted us an increase in cost of well over, I don't have the number in front of me, but it was significant increase, over $100,000 of increased costs. And again, the good news or bad news, depending on how you look at it, we are not unique. In speaking with other administrators, jail meals is one of those things that every county has seen increased costs. Every county that contracts with a vendor has seen increased costs from those vendors. I have no doubt that individual counties have seen that deliver the meals themselves in terms of prepare them, and they do that work. Their costs likewise have increased, but they're in an advantageous position to us in that they have the capacity to at least have the conversation of whether they deliver the meals themselves or continue to do so, or they contract with a vendor. We don't have that ability right now. We have no kitchen from which to put these meals together. This project is a project to allow for that renovation to move forward, to have that option to engage a vendor and have them on site, because we currently still have a vendor do work on site to deliver these meals. It's not as though they bring in meals and there's no kitchen-related space from which they need to deliver the meals. It's just not enough from which to do all of the work that you need to do to cook and prepare the meals. And I'd love to offer you something where it's like, hey, this is a great solution where not only are we going to do this, but we're going to do it and we're going to make money. This is the part of government that I talk about frequently. We're not in the business of making money. We're hoping to have the opportunity to lose the least. The opportunity to lose the least is to at least have control over which direction you're going to go. Right now, we don't. We are going to contract with someone, absent a change, to deliver these meals. In the future, I would suspect we'll still contract with someone. They'll just do the work here. And maybe we get lucky. And they, as Chris said, our kitchen is such that they can deliver meals through contract to other entities to deliver those meals. And we might get a lower overall cost of meal delivery than we would get if we were the receiving entity, which we are now. So you don't have a great answer. This is the least problematic answer we can come up with. And we've tried. As Chris said, we went from the original state of our current vendor provides us a significant increase in cost. We did some outreach to other vendors to see if there's a likelihood that someone else would take on that contract and we wouldn't see as big of an increase. We didn't get good results from those conversations. We worked with North Central, tried to make it work, and I can't say enough things about North Central doing their best to make this work in a very challenging situation. But it's not a long-term solution. And I think, correct me if I'm wrong, but we reached back out to our previous vendor to say, hey, can we jump back on for a limited term contract with them? And that answer wasn't advantageous to us either. So we're really in a hard spot. And this is one of those areas you are mandated, the sheriff is mandated to provide meals. Makes total sense, right? If we're going to have people incarcerated in the jail, we have to provide meals and they have to meet very strict rules in terms of caloric intake, like Chris alluded to. This is the best option we got.
Supervisor Limmer, then Supervisor Marshall.
Thank you, Mr. Chair. I think with the ADRC, we have seen huge problems with our vendors delivering meals for Meals on Wheels and some of the other things. So I really appreciate that question, though. How many kitchens do we have at the county level? When I look at the plan for the Lakeview, if we do a childcare, they will need meals. I know there's a ADRC kitchen that's planned to go in. That will be well used. I think the extension has a kitchen space. But I just wonder the capacity, would the jail be able to then service some of those other things, or would it be better to put something more central at the Lake Shore building now that we just approved that plan?
Well, I think they're very different kitchens in terms of what we're talking about. So the old kitchen in the building that we were discussing previously provided meals for everybody. But that kitchen is, for lack of a better term, out of date. Like the equipment's old. It's not, and it's not the approach that even vendors use. And to the earlier point too about vendors, like the process, we've appropriately sought information from vendors to help inform things along the way. And there may be parts of it in terms of the equipment that a vendor might want to bring in, but we would still be bringing the space or putting the space in to facilitate that. But the UW Extension kitchen is more of a demonstration kitchen for classes, and kind of the way it's most likely going to end up is being like a hybrid conference space. So if you're not cooking, then you can still be convening. The Meals on Wheels area for ADRC is less kitchen, more of just packing area, really, with some access to electricity and some coolers and things like that you all need to make that work. And so you wouldn't really have capacity to make meals there. The daycare, if that were ever to come to pass, there's potential for that UW Extension kitchen to play a role there, but there's also a lot of different rules and hurdles in terms of how daycares operate that would most likely not overutilize that, or any kitchen really. And so in terms of kitchen capacity, North Central is, as I was saying earlier, is pretty maxed out in their current space, providing meals to their clientele. But the other challenge in terms of capacity is timing. So like right now, just as another example of the complexity, is that the nursing home residents and jail residents do not eat at the same time. And so a normal 8-hour shift for people who work in a North Central kitchen is now stretched by multiple hours just to get meals started to prep for the jail. And then you got to go deliver it, but then you got to do the meals for the nursing home. And so you're constantly doing this, which is one of the problematic pieces of that for them. So there may be some capacity for some of the things around the edges of the things you're talking about, even within like the bistro and things like that at North Central. But I wouldn't say anything in terms of like a significant amount of capacity. And that again was part of the conversation in terms of, well, what do you need to provide currently 600 plus meals or up to 800 meals per day. And that's what brought us back to the jail kitchen on site. And the on site piece was also something that we had asked some vendors about, like what would they prefer. And that's also like a recent trend in how some of these vendors approach this is they want like a storefront or they want like a dedicated space to operate within. They may change some of the equipment, but generally speaking, the way they've been providing these types of services is changing even for what they're doing for other people. And so that's helped us in terms shape our planning process and the ideas that we've brought to bear in trying to solve the problem.
Gail?
Thank you, Mr. Chair. I was just trying to remember from the budget, do we still outsource some of our jail population?
Yes. Yep. Every day I check the list every morning. We're anywhere currently between 44 to 55 in the last week that I've seen in terms of housing inmates out.
I know that previous boards said a long-term solution was that we actually needed to build another jail, and I haven't heard that in the last probably 2.5 years. Was that put by the wayside? Because if we're still considering that, maybe this is just a short-term solution, but a costly one if you're still looking at housing all of our inmates locally.
Yeah, I can give you some information about building a new jail, but Wood County is doing that right now, and I want to say that their bids came back in excess of $50 million to build a new jail. So the cost difference between, and this is very insignificant compared to that. That said, it's something I just talked about at the Infrastructure Committee, and I'll talk about at our Budget 101 meeting, working with Chair Robinson, Chair Gibbs, and Christie, is the real importance of scheduling your large construction projects, having a calendar where you schedule and structure your debt payments that come along with those projects, because that's how you pay for them, is through taking on debt and having that service through debt levy, that you schedule those projects. And my sense, the next big project after the North Central Healthcare project that you have on your plate is something that the board has discussed, and that is the relocation of the highway department in the broader construct, of the West Side Master Plan. But this building, certainly, we've done a lot of work to it, but finding where it needs to be on the schedule, the courthouse, and by extension, if there's a new jail, is something that the board is going to have to talk about and put it on that long-term schedule. But you're not going to be hearing from me to start talking about, hey, let's schedule to build a new jail in the next several years, for sure.
Monday's numbers were 173 in Marathon County Jail, 12 in Marquette, 15 in Taylor County, and 25 in Lincoln County. Chris.
Yeah, thank you, Mr. Chair. I just wanted to note that we are going out of our way. I mean, we always do, but we're really trying to find ways to make this as cost effective as possible. So just for example, because there were some pieces of equipment there previously, we've already looked at that, like I mentioned earlier, in terms of the HVAC project we recently completed. Does that handle that space? So yes, okay, we're good to go there. So that takes a lot of the mechanical off. Then previously there was a hood, so we checked the ductwork. We might have to pull that out and weld it so that it's up to code, but essentially the roof penetration is there, the air handler is there, those sorts of things are in place and won't add additional cost. We know the space really well, obviously, that even a drain that was cemented and capped over, nobody had a huge cement budget, so they didn't fully fill the drain. So we inspected the drain and found out that, yes, indeed, we can just remove the cap and now it's usable and we can make that a part of it. Similarly, we've made transitions within that space that there's a mini split air conditioner in there. You don't need that anymore. The plumbing is already mostly in place. There's, we've done a lot of space considerations in terms of looking at what needs to go in to really minimize what that is. And we've tried to, as much as we can appropriately, trying to, vet that out with vendor perspectives too, to say like, what really is the most likely sort of equipment needs to do this. And so the current space is situated well to do it, and we don't anticipate having, it's not like a normal project where you're really going to have to start from scratch. And so in addition, rather than hiring somebody for construction administration, we know the space well from facilities perspective, and we have the expertise that we can do that for the county, which also reduces the costs. And so that should help at the end of the day, bring down the cost to really what are the real brass tacks about getting that completed, if that's the direction we move in.
Other questions? Supervisor Hart.
Thank you, Mr. Chair. And this would be a full kitchen, correct? This wouldn't be like something, just a preparation station that a vendor would use to get all the meals ready, and this would be a full-on. That could be utilized if we were to change directions in the future and not go with a vendor and have to hire in-house staff to make meals, correct?
Correct. The equipment that would go in there would be the equipment you'd need to produce those meals. And so currently, to your point, it's really just a place to pack meals and get them out to the population. But if this were to come to pass, then that space would be where you can actually produce, pack, and distribute.
Any other questions? Not, what are the wishes of the committee? Chair Gibbs.
I make a motion to approve the funding for the capital project, $64,205 from the CIP, and amend the CIP for the out of the ARPA funding.
So is the motion to approve the project and the funding? Okay. Is there a second? Second by Supervisor Lemmer. Any discussion? Not all those in favor will signify by saying aye.
Aye.
Opposed, no. That motion carries. Onward to the amending the 2023 KIP at Eastgate Hall Boiler Replacement Project in the amount of $179,000, $179,300. Been a long meeting. Chris?
Okay, thank you, Mr. Chair. So this one is a legitimate surprise in the sense that we knew it was an aging system in there, but facilities have been taking a heavier hand, let's say, in terms of inspecting and going through preventive maintenance for equipment across all departments. And I had made that clear to the parks and others earlier in the year. And so they had reached out and asked if maybe we could look at this particular boiler, because then they had thought maybe it wasn't working as well as it should. And upon inspection, well, actually, what happened was the thing blew. So upon inspection, we identified what actually took place. Most of it was just tied to age. And then we also noticed that there were some other pieces of equipment, related to that operation that were not operational. So the amount of funding that's being requested includes a boiler replacement for Eastgate Hall and those related pieces of equipment in the same space. The reason it's being brought to you as soon as possible is that we need to get that replaced before heating season happens, because if we don't get that done, then it's going to be very cold in Eastgate Hall this winter. So that's also, you're in competition with vendors who already have bid out a lot of their summer projects, and so we're going to be not necessarily hard pressed, but we're going to be in a position where urgency is going to be needed to get that done on time. The contingency fund was something that I approached just because it seemed contingent, but it could be too that we fund this out of ARPA as well. So that's up to the committee, and if there's other comments about a better source for the funding. But essentially, this is a timing issue and an equipment failure issue. And so moving forward, facilities will be continuing to look through other parks equipment around there to ascertain, like, where are they all at in their life and condition, and then also doing some education for folks in terms of preventive maintenance if they're going to be doing it, but also suggesting that we take a bigger role in doing those sorts of things across, countywide.
Bert?
Thank you, Mr. Chairman. Chris, just a quick question. I know we'd asked facilities and maintenance to do a long-term CIP plan for maintenance of and replacement of facility or of systems such as HVAC on all our buildings. Was this on our radar, and was it initially thought of possibly 2 years in advance? So it's just now a timing of when we're replacing it, obviously out of necessity?
Yeah, I'd say it was on the very edge of the radar. And I say that just because facilities has completed what you're talking about for all of the highway shops outside of the main shop. And so we've been completing that for highway. Parks was on the horizon. That's why I initially reached out to all of them to say, hey, we're going to start going through this stuff to see, to get from a facilities perspective anyway, from our HVAC individuals, where is all this at? And so, yes, it's on the radar. It's going to, I think, the intention, but my intention for sure is to have it firmly on facilities radar to the point you were making there, so that we really have a good lead on all that, and then you've got a replacement cycle and all of this roped into the overall approach we have for capital improvement planning. But yeah, really the driving factor for this was just it was an older piece of equipment that still had some legs, but ended up just kicking the bucket earlier than we thought.
Supervisor Lemmer, and then Administrator Lemmer.
Quick question. How does this fit, two of them actually, how does this fit with the West Side Master Plan that is envisioned? And then do you know how this impacts, or this could impact summer and fall activities at Eastgate Hall?
To the second question, I don't think we'll have any impact there. I mean, the work would be taking place in that very specific location. I think in terms of summer activities, you could talk about chilling the space, but really that's a want. That's not a need. This is a need in terms of heating season, and also in terms of the West Side Master Plan. I'm not as well versed in that as Parks Director is, but I would say that Eastgate Hall is still a main component of that plan, and so I don't see that going away. And so regardless of whatever we do in Eastgate, you're still going to want to have this completed so that that facility is usable, but also once you start getting those colder temps, you don't start running into other issues in terms of freezing pipes, things like that, or even the sooner we can get air handling working the right way, you have less issues about mold and dust and other sorts of things because you've got the kind of air movement you want. And it's not posing an immediate issue now, but it is an issue in terms of timeline and getting it done as soon as possible.
Administrator Leonard.
Thank you, Mr. Chair. Just going back, first I'll kind of add a little bit additional information to what Chair Gibbs was referencing. It's called a computerized maintenance management system, and this was something that the board approved funding for, just for individuals that perhaps haven't been on this committee or haven't heard of this project. I want to say that was back in 2017 or 2018. And as Deputy Administrator Holman referenced, really that system began with, it's a facilities-led project, and facilities for, well, as far back as I can remember, really was in charge of certain buildings. And then we had the buildings that Deputy Administrator Holman referenced. Our highway department really largely kept control of the buildings. They were responsible for not only the Wausau shop, but really for all the maintenance within all the shops. Similarly, parks. They had facilities budgets and facilities plans. They weren't rolled into that computerized maintenance management system. So what you do when you purchase one of those, it's, as Deputy Administrator Holman referenced, you put in all sorts of information, all the mechanicals. It gives you some sense of what the preventative maintenance is for your various roofing materials based on your buildings. And it gives you, again, good insight on what is going to happen. It's not going to hit everything right? You're going to have some things that need replacement a little earlier, and some things maybe you can keep along a little bit longer, but it's really a helpful tool. One of the things we started beginning in 2020, one of the conversations I had, and Chris is continuing that, is how do we move in a direction where facilities really is over all of our facilities? And that's a bit of a struggle because facilities, likewise, we have a lot of buildings that they're already responsible for. At the same time, we're doing a lot of renovations, which we've already talked about today at our Lakeview Drive campus. So they've been eating that elephant one bite at a time. And I would love to have said that we could have eaten the bite at Eastgate Hall a month earlier than we had planned on. But as Chris said, sometimes mechanicals just fail. And that's what happened here. We were going to head out and look at it, and it failed. So it's really one of those projects that your contingency fund would normally be used for, quite honestly. Whether or not you use the contingency fund or decide to use American Rescue Plan Act funds is absolutely a discussion that this committee can have. I can see arguments to do either one. It really doesn't fundamentally change the need to move forward with this project. But to Supervisor Lemmer's specific question, Eastgate Hall within the West Side Master Plan, it is one of the very widely used buildings. And as Chris referenced, if this project were not to move forward, your ability to use that would be dramatically changed. And for a lot of reasons, I can see why you'd want to continue that. But to go back to the West Side Master Plan, there are a number of enhancements that are called for within that plan. Nothing specifically referenced within the plan relative to mechanicals, but really more aesthetic updates to that building to enhance its usability. One of the big things, apart from kind of those things you always need to update over time, flooring, roofing, other things, really enhancing the functionality relative to noise. For those of you that have been in that building, it can get loud if you have a large group, but nothing specifically relative to this. So those projects would still need to be moved forward at a later date. They would go through the capital improvement planning process. And I'm not sure if Jamie has anything envisioned for 2024, but certainly they wouldn't impact this project moving forward in the timeline that Chris referenced.
Just a comment. I support the resolution, but I was particularly troubled by both this and the previous resolutions, whereas the capital improvement program is a dynamic process and subject pursuant to periodic review. I don't think we want it to be a dynamic process. I think we want it to be a thoughtful planning process, and the use of the word dynamic means that we can be changing it whenever we want. It was a troubling whereas to me, and we're trying to, I think, utilize the software and other things, and I would like to not use those terms because we're trying to respond to an emergency, basically, or a critical need. And maybe it's being petty, but I think we're trying to set things in motion and have that longer-term plan with a little bit more certainty.
For what it's worth, I 100% agree. And, you know, I stole that whereas clause from previous resolutions that did this similar sort of thing. So I'll strike that one in the future.
Supervisor Hart.
Thank you, Mr. Chair. I just wanted to know how much was currently in our contingency fund.
Christie.
We have that number. There was an $800,000 contingency fund approved for 2023. Of that amount, $750,000 is the county board contingency. If this gets approved with a contingency fund, it would be taken out of that bucket with a 2/3 vote of the board. The other $50,000 is called the Finance Committee contingency. It was established in the budget resolution. That is money that is able to be approved directly by this committee for any contingencies 50,000 or below. And so with the 800,000 in total, take out this 179,300 for the Eastgate boiler. There's been no other contingency fund requests. That leaves 620,700 in total. And it still continues to have your 50,000 remaining. And that would leave 570,700 in the total county board contingency fund.
Chair Gibbs.
Thank you, Mr. Chairman. The challenge that I see if we utilize contingency is we may get into, obviously we've got a lot of the year left. We've got a lot of large potential trials, and that can run into significant overruns in costs and budget items. The question becomes, would this be eligible for ARPA and bringing it in under an ARPA funding project? And so the question then becomes, what have we allocated for ARPA, or what is our long-term plan for ARPA? And so I would tend to lean on utilizing ARPA if ARPA is available for this project. That would
Christie?
be my thought.
ARPA's available, and we had talked about that, but when the comment, it blew up, I decided that contingency sounded better right now, but either one is available and available for you to use for funding for this project.
So are there any other questions or comments or motions?
But even, Mr. Chair, if I might, but even if we chose to use ARPA, we could use it under lost revenue? Correct. Okay.
Any other questions, comments, or motions? Chair Gibbs.
I'll make a motion to approve the resolution to amend the 2023 capital improvement budget with the Eastgate Hall boiler and the funding source be identified as ARPA.
Was that the second paragraph? Is there a second? Second by Supervisor Leahy. Any discussion? If not, all those in favor of the motion will signify by saying aye.
Aye.
Opposed, no. That motion carries. All right, motion, we have a closed session item. What are your wishes? If somebody would like to make the motion, they should read it. I'm seeing frowns. Do we really have to do this? Chair Gibbs.
I'll make a motion to go into closed session pursuant to Wisconsin State Statutes 19.85, Parent 1, Parent E, for the purpose of deliberating and/or negotiating the purchase of public properties, the investing of public funds, and conducting other specific public business whenever competitive or bargaining reasons required a closed session. To wit, review of appraisals for and discussion of strategies regarding the potential sale and certain county property located at 616 Forest Street in the city of Wausau and the potential purchase of private property adjacent to the county-owned properties.
Is there a second? Seconded by Supervisor Lemmer. Any discussion on the motion? If not, the clerk will call the roll.
Robinson.
Aye.
Leahy. Gibbs.
Aye.
Marshall.
Aye.
Hart.
Aye.
Lemmer.
Aye.
Thank you.
That motion carries. We are in closed session. We would ask that you